we are back. I'm your host, Barry Waxler, here with my co-host, Andrea Kay, and Urban Miaris. And we have our first guest, Mr. Scott Burdman from Burdman & Ward. Welcome, Scott.
Thank you. Thank you for having me.
Great. Well, with the diversity in legal practice around the country, around our city, tell us a little bit about what you do.
We do one thing, we do it well. That is construction defect claims. And we do plaintiff's work. We represent only homeowner associations and individual homeowners in construction defect claims against builders and developers for defective construction.
Okay. So a lot of construction defect. How long have you been doing it?
Been doing it for 27 years, since 1987.
1987. So, and you work primarily with homeowners associations, correct?
Yes, the majority of our clients would be condominium homeowner associations. They're usually frustrated. They've had some dealings with the developer, and the developer's non-responsive to making repairs in their community, or they're just making temporary Band-Aid repairs. And out of frustration, they oftentimes will then call us.
Okay, out of frustration. So, when do you typically get called into a situation? I mean, it's not when the first drop of water leaks out of the faucet.
No, oftentimes we're called several years after the condominium complex has been built. In California, you'll typically have up to 10 years to bring a claim for latent or hidden construction defects. So usually when a homeowner association sees a pattern of problems, they get a serious rain and maybe 20 or 30 units have water intrusion through the windows or the roofs. Then they start thinking, hey, there's a potential problem here. They oftentimes speak with their community property manager, who then may recommend that they contact someone like our firm.
Okay, interesting. So, so it's usually when you see a block of the same thing going wrong throughout the complex.
Absolutely. Every complex is going to have some problems. No homes are built perfectly. But when you start seeing that 20 or 30 homes are having large stucco cracks, or the driveway slabs are lifting up because of soil movement, or 30 homes have water intrusion through their balcony decks or roofs or windows, that's a pattern that you can't ignore.
Mm-hmm. Wow, interesting. And so you end up sometimes getting into litigation and sometimes just getting into negotiation to fix the problems for the clients. Is that correct?
That's correct. I mean, first and foremost, we always reach out to the builders, and we always tell them and our clients, listen, if you're willing to make permanent, proper repairs and not just Band-Aid repairs that are just going to last this season, everyone's going to be dollars ahead. But oftentimes the builders aren't willing to make the permanent repairs, and then we have to start the process of going toward a construction defect lawsuit. In California, you can't just run out and file a suit. You have to go through alternative dispute resolution and a process set forth in the California Civil Code.
Interesting.
What percentage of the time does it go all the way to litigation, or what percentage versus you send them the letters and tell them, look, work with us, or it's going that way?
I would say maybe 15 or 20% of the time you'll get a responsible developer who will come out and actually make the repairs, and then it won't go toward litigation. But probably 85% of the time it goes toward litigation or into litigation.
Well, with your success record, you would think that they might be willing to come to the table with some kind of resolution to avoid the damage.
Well, we always want them to do that, but oftentimes the developer won't come to the table to settle the claim until they have an idea as to how much money their subcontractors, their subcontractors insurance company, are willing to put in to make the problems go away.
So is it really them or the insurance company that's really being sued?
Well, it's them that's being sued, but these cases are oftentimes driven by insurance coverage. A developer may want to settle the claim, but they're not going to come out of pocket $7 or $8 million to settle the claim until they have a good idea of how much of that they're going to recoup from their subcontractors who also had to procure insurance to work on the project.
Yeah, it's interesting. I see some of these settlements here. The Heritage Village, $14 million. Ranchwood Park, $12.7 million. This is serious stuff.
It can be very serious, and depending on the nature of the claims, and we have a claim pending now involving 812 individual homes. It's not a condominium homeowner association claim. These are in a large planned unit development, and we strongly anticipate that claim will exceed $15 million.
Wow.
Nice.
Wow.
Yes, we're looking forward to that. It's a lot of work, though, to get from the start of the suit until it's finally resolved, either by settlement before jury verdict.
So it almost sounds like a boxer looking to get ready to get in the ring. You really want to get there.
We want to get there, and we're very passionate about the work that we do. We want happy clients. We want to recoup enough so that after payment of attorney fees, expert fees, our clients have enough money to make the permanent repairs they so desperately need and deserve.
Interesting.
Yeah, and they do deserve it because I mean, this is the American dream. So much of the American dream is home ownership, and so many people just save and save and save for that down payment. And this is, they can't afford for these repairs themselves, and it's heartbreaking. And so, a lot of people out there might be thinking, gosh, these, attorneys just, raking the developers over the coals. But no, I mean, these are legitimate claims.
Oh, absolutely. And, probably 99% of our clients, the largest investment they have is their home or condominium. And so it's so very important to them that they get it fixed and they get it fixed properly so that the value is going to be there. And when they go to sell it, they can make disclosures. Yes, there once was a problem, but the problems have been resolved. Mm-hmm. When we represent homeowner associations or homeowners, we do so on a contingent fee basis. Mm-hmm. So our clients aren't out of pocket a penny till we get a recovery for them. We also advance 100% of all the expert costs and litigation costs until there's a recovery. So we don't take a case unless we're very convinced that it's a viable claim, it's a legitimate claim, it's a substantial claim, and there's a pocket to recoup from.
Wow, that's great. You're listening to Close Up on Syndicate Business here on Bloomberg Radio, KFSD AM 1450, and we stream live on the web at financialnewsandtalk.com. Send us a tweet at CloseUpSD or Facebook /CloseUpSD. We want to hear from you. I'm your host, Barry Waxler, here with my co-host, Andrea Kay and Urban Miaris. And our guest is Mr. Scott Burdman from Burdman & Ward. So I'm looking at your 10 reasons to hire Burdman & Ward. Some interesting stuff. Number 5, you have your law firm is AV rate the highest rating from Martindale Hubbell. Tell us about that.
Well, what that means is, first of all, Martindale Hubbell, this isn't something that you buy a rating. It's based on peer review by other attorneys and by judges. And we have the highest rating for legal ethics and for legal ability. We're very proud of that.
That's great. That's great. So
so no lawyer jokes about your firm.
Oh, lawyer jokes are always funny.
Yeah.
I just have never heard a funny one.
Oh. Hey, I've got a question. Yeah. A homeowner becomes disabled after, let's say, a wheelchair user. I understand that the homeowner is responsible for a lot, but how much would the homeowners association be responsible for? What I'm specifically saying is the outside sidewalks or the entryway, especially in a power chair, because they need a little bit bigger landing, a wider landing for the power chair.
Well, there are ADA requirements about sidewalk access and everything else, and we've actually had a couple of cases where the builder did not build them in compliance with the ADA requirements, Americans with Disability Act. So that has become part of the claim. Mm-hmm. So the homeowner association has to do everything they can to try and accommodate the disabled individual homeowners.
Okay. Yeah, I know you're in a number of states, and each state has its own addition to the ADA, their own definite. Title 24 in California is an example.
Correct. Yeah. Correct. And we practice also in Arizona and in Nevada. We have offices in Phoenix, Las Vegas, Sacramento, as well as our main office in San Diego, where we work out of all of Southern California.
Now, have you always been on the plaintiff side, or did you start out in insurance defense?
No, I've never been on the dark side. So we're very proud of the fact that we've always been on the plaintiff side, and we only represent homeowner associations or individual homeowners in construction defect claims. We don't defend any developers.
Right. Wow. And most of it is the association. I think we talked about this before. About 80% of your business comes from the associations.
That's correct. And it's so important, too, when you're working with these associations or individual homeowners, communication. That is the number one thing. You've got to be in constant communication with your clients. Tell them what's going on. We always give them our cell phone numbers. We want them to be able to reach us.
You give your actual cell phone number out, an attorney?
Yes.
Wow.
And we want our clients to be able to reach us. And we hear so many times, geez, our attorneys don't communicate. We rather be accused of over-communication than not communicating with their homeowners. And with smartphones, emails, and cell phones, you should be able to be in constant communication with your clients. Tell them everything that's going on, because it can be stressful for the clients to be in a lawsuit. And you have to be empathetic that They are very concerned about this. They need to know what's going on. They need to be in the information loop. They deserve that.
Yeah, one of the other things I see on here is how you employ a lot of experts to help you out. A lot of leading forensic construction experts, what have you. So really, you have a lot of connections to help. It's not a matter of just taking the case; it's putting it together properly.
Yes, and we rely very heavily on architects, contractors, civil engineers, structural engineers, soil engineers, and we want them to tell us what's wrong and how do you fix it permanently. And we try and work with experts. I've worked on both sides of the fence, meaning they've defended developers and worked with homeowner associations because they're going to be more credible than an expert that does 99% of their work just on the plaintiff side or just defending developers.
Well, tell me about that. I saw that you have a recent award from San Diego Magazine. Tell me about that.
Oh, it was one of the top lawyer awards that you get, and that was in the construction litigation field. So I was pleased to receive that.
That's great. I mean, the lawyers are like the insurance and the real estate industry. There's a bazillion people out here trying to compete for the same business. So when you find somebody that rises to the top to get those awards, I like to bring that out to the public.
Well, I greatly appreciate that, and we always give complimentary inspections and consultations with any potential clients. No cost, no obligation. We come out, we meet with our potential clients, we bring experts. We audit the property to see what kind of problems are really going on.
And I bet that with the success that you have, that builders and developers are actually probably providing a better product now, because if they don't, they're facing you at the end.
I think that the quality of construction has gone up over the last 10 or 15 years, specifically in Southern California, as a result of a lot of construction defect claims. So that is a benefit of the construction defect litigation.
Yeah.
Awesome.
Interesting. Well, we're starting to run short on time. Tell our listeners how they can find out more about you or contact you however they need.
Sure. Well, first and foremost, they can go to our website, which is www.burdmanlaw.com. That's BURDMAN law.com. We're in the process of doing the Facebook, Twitter, everything else. We should have that up and running within the next 30 days.
Okay.
And we'd welcome the opportunity to speak to people if they have any concerns about their condominium project and how the common area components are performing, or their individual home, especially, of course, if the project or home is under 10 years of age.
Great. Well, I welcome our listeners to give us a tweet here or there at closeupsd or at closeupsd. And if you have any questions for Scott, send them over. Go to his website. Come to us. Scott, I appreciate you being here.
Thank you very much for having us today. It was a pleasure, Barry and Andrea, and also Urban. Thank you.
Great. Thank you. You're listening to Close Up on San Diego Business, where we get up close and personal with homegrown San Diego businesses and the people that are working hard to make a difference in our community. We do want your feedback on Twitter at CloseUpSD and on Facebook /CloseUpSD. I'm your host, Barry Waxler. We'll be right back after a word from our sponsors.